Immigration attorney Pegah Rahgozar. Thank you so much for joining me for another episode of Wednesday Wisdom with Pegah. Our principal office is here in Houston, Texas, but we do take cases from all over the U.S. and across the world, advising on U.S. immigration laws. Our office phone number is 832-792-3636, and you can learn more about this topic as well as about me and our law firm by visiting our website at www.rahgozarlaw.com. I hope everyone had a wonderful new year and are off to a great start this new year. I wanted to briefly discuss in today's topic about naturalization and citizenship process and requirements. But before I dive in, as usual, I'd like to inform you that any information discussed in today's video is for informational purposes only and should not be construed as legal advice. Every case is different, and because immigration is a fact-intensive area of the law, it's best that you seek the proper advice from an experienced immigration attorney before filing any sort of application for immigration purposes. Just a reminder, although we are experiencing the government shutdown, USCIS is one of those agencies that is not affected by the government shutdown, and that is because your filing fees that you apply for immigration benefits through USCIS that's how the agency is funded, so therefore they're not affected. So if you do have scheduled appointments or interviews, be sure that you are attending them because their offices are open despite the government shutdown. So the process to become a U.S. citizen can be tricky, but basically you are a lawful permanent resident or a green card holder and you want to know how to become a U.S. citizen. Well, great. This video is just for you. And no matter how you became a U.S. permanent resident, whether it was through employment, through a U.S. citizen spouse, or it was through asylum or any other means, the final and last step in the immigration process is to become a U.S. citizen. The process is called naturalization, and it's filed on the form N-400, available on uscis.gov. To naturalize, there's actually several benefits as to why you actually want to go through this process and become a U.S. citizen. One is your U.S. citizenship never expires. Unlike a green card that expires, whether it's a conditional resident card valid for 2 years or it's a permanent resident card valid for 10 years, once you become a U.S. citizen, that's it, absent of course certain circumstances, such as if you lied to get where you're at, or you had some sort of criminal history that you failed to disclose. Other than that, you're pretty much set once you become a U.S. citizen. Two, you can get a U.S. passport and be able to travel with it and not have to worry about all the requirements of maintaining your green card and going abroad and staying, up until 6 months and whatnot. With a U.S. passport and U.S. citizenship, you're able to travel freely with no, time limits on how often and how long you can stay outside the country. Three, as a U.S. citizen, you're allowed to vote in U.S. elections and have your voice heard. 4, you're eligible to also run for certain public offices. 5, you're eligible to receive certain government benefits and federal aid. And 6, you're not subject to deportation from this country. So that's always wonderful. As with any application, every question on the citizenship application must be answered with care and truthfully. Naturalization is your important final step in your immigration journey, so you want to be sure that you're not careless with the application and you pay attention in both the properly filing it and attending your interview to ensure that this process goes smoothly for you and you can become a U.S. citizen. Now, after a certain amount of time of maintaining your lawful permanent resident or green card, you're eligible to apply for naturalization. Now, the time frame is usually 5 years for most people, and 3 years for those who are married to and residing with their U.S. citizen spouse. You're eligible to apply for naturalization, and basically how some of the requirements works in terms of calculating time for continuous residence and physical presence, which I'll get to in a moment. You count backwards the 3 years or the 5 years from the time you decide to file for naturalization. So if you were to apply today, you look back 3 years if you're married to a U.S. citizen and residing with them. And 5 years if you are just filing on your own as a normal permanent resident, not married to a U.S. citizen. The requirements for naturalization itself is one, that you have to be 18 years old or older. You must have lived in the current residence or in your jurisdiction for at least 3 months before filing your application. So if you're abroad for whatever reason and just got back like a month ago, you have to wait the 3 full months before filing for naturalization. unless you happen to serve in the armed services or qualify for other exceptions. Another requirement is you must be a person of good moral character, and I'll describe what elements usually people get in trouble for good moral character that they might not be able to meet or might need the expertise of an immigration attorney. And finally, you must meet both the physical presence requirement and the continuous residence requirement, which can vary based on each specific case and circumstances. Now, 3 key areas will determine if you're eligible for naturalization now, or at a later time, or possibly never. But each case, of course, is different, and you'll need to seek the proper advice of an immigration attorney to see whether that's something that pertains to you, whether you can actually file now, at a later time, or possibly never. One key area is good moral character, as I just mentioned, which is often determined by your criminal record, if any, or it could even be related actually to not paying child support. And these issues, whether it's crimes or child support, can come into play whether it's here in the US or it's outside the US. So if you have any criminal history at any point in your life or anywhere in the world, not just in the US, this could actually be a concern, and it's highly advisable that you do speak with an immigration attorney to make sure whether you should file or what the consequences of filing could be. Every state, of course, has different criminal statutes, and they have different punishment levels, and those have to be compared to the federal guidelines for immigration to make sure that you're in fact eligible to, 1, become a U.S. citizen, and 2, wouldn't really be a deportable offense should you be denied citizenship for some reason you're not actually placed into removal proceedings. Usually a good rule of thumb, though, is if you've ever been convicted of a crime that has at least a 6-month or 180-day jail time, then there could be a problem. Even though you never actually served a day in jail, that could still be an issue if the conviction could be at least minimum 6 months or more of jail time that it carries. The details and facts, of course, of your crime have to be disclosed to immigration, and in most cases, they want documentation and proof of the crime and the conviction and the sentencing as part of your application. If you fail to disclose that information, however, that could be grounds for you to lose an opportunity to apply for citizenship. It could also be grounds for them to denying your citizenship application, or worse, they could actually put you into deportation proceedings. So you want to make sure that you do your due diligence, you speak with an experienced immigration attorney, you make sure you in fact do qualify to file for naturalization before filing if you do have any crimes. Even if you do happen to slip under the radar for any chance because you failed to disclose or because the officer overlooked it for whatever reason, and then they later go back and review it, but nonetheless you've been granted citizenship, the government can still go back and revoke your citizenship. So this is something that you don't want to mess with. If there's any sort of criminal history on your record, anytime, any point in your life, with whatever visa you've been under or a green card, here in the U.S., outside the U.S., things like that, you want to seek proper advice. So if you do have any questions about good moral character issues or unpaid child support here in the U.S. or outside the U.S., be sure to contact our office at 832-792-3636, schedule an appointment, and we can discuss your case further. A second and third key grounds, which I'll get into, are things that I routinely see with individuals. And those are the physical presence requirements for naturalization and the continuous residence requirements. So for physical presence, you're required to be physically present in the U.S. That means on U.S. soil for at least 30 months of the 5 years. So that's basically 913 days of physically present in the U.S. Now, of course, if you're subject to the 3-year filing because you're married to a U.S. citizen, that requirement is 18 months of physical presence in the U.S. And USCIS will count the day that the applicant departs the U.S. and when you return as a day of physical presence for naturalization purposes. A third key area that you want to be mindful of that factors into whether you are in fact eligible for naturalization is whether you meet the continuous residence requirement for naturalization. And this I see too often. I usually see this with my elderly clients, a lot of Persians, Indians, Pakistanis. They love to get their green card, come visit the U.S., every few months for 2 weeks and then go back home. Well, unfortunately, you have probably broken continuous residence. and I'll kind of dive into what those requirements are. So even if you meet the physical presence requirement for naturalization, your case can still be denied if you don't meet the continuous residence, because although they're kind of interrelated, they're kind of not. You have to meet each on their own. So continuous residence means that you actually maintain residence within the U.S. during the 3 or 5 years, and you have to continuously meet that. So any extended absences outside of the U.S. can disrupt continuous residence. So absences of more than 6 months to 1 year, there is a rebuttable presumption that you have disrupted continuous residence. And what that means is that you can rebut that presumption by providing supporting documentation, evidence, and of course your testimony at the interview is also part of that, as to proving up whether you in fact did or did not disrupt continuous residence. The second thing is any absence in excess of 1 year or more, that definitely disrupts continuous residence. And we see a lot of people kind of get by with the 6 month to 1 year absence if they have a lot of documentation in support of it, like medical issues, work-related matters, things like that. I mean, you have your documents in order, evidence to support that. We've seen cases go by and you are still eligible and get granted citizenship, whereas over the 1 year period, those get a lot more trickier. And so in either situation, if you have issues with continuous residence, be sure to seek an experienced immigration attorney to discuss your case. And of course, there are certain exceptions that apply to all this, but I won't really be getting into that. So this is just general requirements. But if you do have any questions about physical presence or continuous residence, then please feel free to reach out to our office at 832-792-3636. Make an appointment and we can discuss your case further. So what happens after you file for naturalization? Now, assuming you have no issues and you are in fact eligible to apply for naturalization, after filing within a few weeks, you receive your fingerprints and biometrics notice where you go take your fingerprints, and that basically USCIS does their complete background checks on you up until your interview, and sometimes it could take longer after the interview. Depending on how the wait time is based on your local office, then you'll receive an interview notice. Some places are 6 months or 8 months. Other places are seeing a 1.5 year wait time. So once you're scheduled your interview, you'll attend your interview with the USCIS office that's in your local jurisdiction. Of course, if you move, do submit a change of address so that USCIS is informed where to send your file, and that could also cause additional delay in your wait time for the interview. During the interview process, the officer is going to go over your entire application history. Every question is going to be asked on there, things about your employment, your residence history, your travels, any criminal history, things like that. You're also going to be given an exam to test your civic knowledge on U.S. government and history, as well as if you're proficient in the English language. And there's both a written and the verbal component of the interview. In certain circumstances, the English test can be waived. But for the most part, most applicants have to be able to be fluent, or not fluent, but at least proficient enough to get by on the interview and answer the officer's questions. Also, during the interview process, you're eligible to provide any more supporting documents that you didn't initially submit with your application, or if you have documentation, for instance, if you have questions that come up for continuous residence, you have your documentation there to be able to provide for the USCIS officer to review and put into your file. If the officer feels that you have passed all portions of the examination and interview, then he can make a determination on your eligibility and approve your naturalization case on the spot, and then you'll later be scheduled for the oath ceremony where you'll be sworn in to be a U.S. citizen, a naturalized U.S. citizen. Of course, depending on if you have certain issues, though, the USCIS officer can put your case on hold before making a final determination. They could schedule you to come back in for a second interview. I've seen that usually happen in cases where there might be possible fraud, and they'll bring you back in to be scheduled with a USCIS officer trained in the fraud area. Or they may ask you to provide additional documentation to support whatever the issues are in your application before they make a final decision. And last but not least, they can deny your case and either just tell you you're eligible to reapply at a later date, or tell you that your case will be referred to immigration court because for whatever reason, maybe your case, maybe because of the criminal grounds, you're now subject to deportation. So it is very crucial that you seek the proper advice from an immigration attorney before filing. Sometimes even cases that seem very straightforward end up being complicated because individuals didn't work with an immigration attorney. So if you do have any further questions about your eligibility to file, or if you have been denied citizenship and you want to reapply, then please contact our office at 832-792-3636. Schedule an appointment, and we'd be more than happy to discuss your case. So I did have a few questions that came into me earlier that I will go ahead and dive into, and then I'll go ahead and address. Ms. Lopez Esmeralda is asking a question. I'll get to you in a second. So I had an individual ask me, send me a question asking me that they've been deported 4 times. Are they still eligible for anything? And although the answer generally is no, it still is dependent on each person's case, because a lot of times after interviewing these individuals and reviewing their case and their fact history and their immigration history, we come to realize they may be eligible for a U visa, a T visa, which are crime victim visas and trafficking victim visas, or for VAWA, Violence Against Women Act, despite the title, VAWA also applies for men. So individuals who have been married to a U.S. citizen, who have been subject to abuse, physical, emotional, psychological, things like that, those individuals may actually qualify despite their deportations. So yeah, as I previously mentioned, just call our office, schedule an appointment. We'd be more than happy to discuss your case and see if you are in fact eligible for anything at all. Our office phone number, 832-792-3636. Another individual asked, they're married to a U.S. citizen. What is the processing time for getting a work permit? I had actually addressed this question, I believe, in a previous video, but I'll go ahead and address it again. So the average processing time to get your work permit is about 6 months. You'd still need to check the USCIS processing times online, but that's the general time frame. If you feel like it's gone over the processing times, then you can call the USCIS 1-800 number, make a processing request, and they'll look into it and get back to you via email or mail you your work permit sooner, or whatever the situation may be, they'll be able to better assist you. As far as the interview goes when you're married to a U.S. citizen, that is going to be, again, dependent on where you live. So some cities, they might be able to be interviewed under 1 year. Other cities, they'll take over 1 year for the interview. Houston here, it's taking about over 17 months on average for marriage-based green card interviews to happen. I had another individual ask, they came to the U.S. and they want to apply for asylum. So asylum is a very complicated area of the law. It's best that you do work with an immigration attorney. Some of the basic requirements, however, is that you want to file for asylum within 1 year of your entry into the U.S. There are exceptions for the 1 year, but it does make your case a little bit more difficult if you've waited that long to file for asylum. But again, speak with an immigration attorney. Nowadays, a new policy memo actually came out at the beginning of 2017, where USCIS is doing kind of the last in, first out LIFO method, where if you recently filed your application, they're looking to interview you a lot quicker than those who have been waiting 3-4 years out. So those, so you want to make sure you have a properly filed, thorough application, because you're going to probably receive an interview after filing for asylum within 1 or 2 months. So you better be prepared, have all your documentation ready for your interview, things like that. Because if during the interview your officer denies your case gets referred to immigration court. So that means you're going to be facing deportation proceedings, and then you're going to have to reprove up your case to an immigration judge. And they're going to make the decision ultimately whether you're entitled to receive asylum and stay in the United States, or they're finding you deportable and you'll be returned to your home country. So Ms. Lopez is asking, my son is getting married with a U.S. citizen. She is 19. Can she ask for it? Generally, USCIS deems a child someone who is under, or I'm sorry, immigration laws deem a child someone who is under the age of 21 years old. However, if you are married in circumstances like that, even though she is 19, yes, her as a U.S. citizen can apply for your son. I have another question. I also have a DUI in 2014. After my interview, the immigration officer told me that this is not the only thing on its case. Happening was less than 5 years. What does that mean? Oh, so that basically, so the individual is asking that they had DUI in 2004. After the interview, the officer told them that it's not, that although it's not disqualifying them, they're going to have to talk to their supervisor and figure out the timeline, because the misdemeanor happened within the 5 years. So that basically goes to when I talked about you have to have, you basically have to meet all your eligibilities, including good moral character, within that 5 years that you're applying. So likely when you applied, that crime occurred in the past 5 years of you applying for your naturalization. So they still had to consider it because it was within the statutory 5 years. Now, generally, if you're applying under the 5 years, then they look in the 5 years for any crimes that you have. But at their discretion, they can go beyond the 5 years and look at any crimes. And of course, if you're married to a U.S. citizen, they'll look at the 3-year history, but again, they can go outside the 3 years for any crimes that you have. So for Cyrus, that's probably what happened, is that your DW or DUI, I'm sorry, happened within the 5-year application period that they were looking at, and they had to consider it still for good moral character. Yes, Mr. Mustafa King has a question. I'll wait for him to post his question. So, Mr. Jafir Sheikh, what does it mean that the I-130 case has been transferred to a new office and the office has jurisdiction? So because of the backlog, a lot of these cases are being shuffled around to the various different processing centers. So that is likely what happened to your I-130 case, is that it moved from one office with a heavy backlog of cases to another office who's now processing your case. It doesn't really mean anything. It's that they're trying to help process these cases faster. And yes, so how long after to get the work permit? I've already addressed that. It's taken about 6 months to process. If it's already been after 6 months, you're welcome to call the USCIS 1-800 number, address your concern, and they'll let you know if it's within normal processing time or outside. And I'm still waiting for Mr. Mustafa to post his questions. Otherwise, I will be ending this video shortly. So, in case anybody else has any questions, well, you're welcome to continue to send us your questions to my direct Facebook group. You could put it into this chat. You could email or call the office. If it's general questions, I'd be able to answer them if they're, fairly simple and basic and kind of straightforward. If it's a lot more fact intensive where I really need to dive into your immigration history and your background, then please do schedule an appointment so that we can talk about your case. Once again, our office phone number is listed here, as well as it is 832-792-3636. Also, as I mentioned before, I do have my article that I wrote about naturalization and citizenship. The link that's on my website is also linked here to the Facebook Live, so if you wanted to read about that. How many days does it take to get a U visa approved after the biometrics? Well, before it used to take about 4 or 5 years. Now, because of the number of visas available every year, there is only so many visas available, and so the backlog has extended now anywhere from 6-7 years to almost 10 years. So it really depends. It's not as quick as it was before, so I would say be prepared for a long wait time. I'm sorry, Mr. Mustafa, I'm not understanding your question. I will be ending this video chat or video call, I'm sorry. And so if you do have any questions, just continue to send them. I'll be able to address them at next week's episode of Wednesday Wisdom with Pegah. I appreciate your time, and I look forward to speaking with you guys next week. Have a wonderful day. Take care. Good night.